So welcome for us to Sutton Group Summits. We're excited with this partnership that we're about to embark on. I would like you to do a quick introduction of yourself. It would be lovely to know exactly what you do and what your specialty and services are involving, so that moving forward we know who to contact with this issues pertaining to this specific topic.
Sure. Greetings, everyone that's in attendance. Firstly, Sabiha, thank you for inviting me to speak with your brokerage. So thank you to Sutton Group as well as Summit Realty Inc. for inviting me to speak about some of the landlord and tenant issues that many realtors and their clients are going through, especially post-pandemic that we're seeing right now. A little bit about myself. I'm a licensed paralegal. I am currently operating under the banner of Justice Matters. That is my firm that I'm operating under. My office is located in Mississauga. However, I service clients all over the GTA. When it comes to landlord and tenant matters, currently things are still online. So we have clients all over the province that we are servicing when it comes to issues pertaining to landlord and tenant matters. My focus over the past couple of years especially, has shifted from small claims court, more so now specializing with landlord and tenant matters exclusively. It has gotten really busy since the pandemic, dealing with LTB, specifically the Landlord and Tenant Board, and the issues that landlords are facing. I would say 95% of my clients are landlords. On the odd occasion, I do represent tenants as well, which is a good thing to do because it sort of gives you the other side as to how to deal with it and what type of issues one can sort of expect when dealing with tenants as well. I've been licensed as a paralegal since 2013, and it was around 2015 that I started my own firm under the banner of Justice Matters. And although I'd started out dealing with small claims court and civil litigation, I eventually segued into fairly soon after dealing more with landlord and tenant matters, and that's sort of become something that I prefer to exclusively practice. Although there is some intertwining between the landlord and tenant board and small claims court, landlord and tenant board is where I prefer to practice at the moment, and that is where my, I would say, expertise would lie. I don't, first and foremost, say that I know everything. A lot of the, sometimes the law is ever changing as well. We have a lot of circumstances, new bills, new acts being passed that would impact, the landlord-tenant relationship. So things are ever changing and we are having to adapt. So even if I don't have the answer, immediately at this session, I can always get back to you. Notwithstanding, a lot of the issues that I'm sure the realtors and your clients are facing are going to be very common. So I'm hoping we can have a very general and broad discussion today with some of the issues that many landlords are facing.
That's amazing, Farhan. So guys, Farhan and I've been having fairly interesting conversations, a couple of them at least previously, and pertaining mostly from questions that I do get from our realtors. The number one key question, obviously, that hits all our palettes is that when our clients come to us and say we want to list our property, which is tenanted, right? And we are faced with all kinds of things like, can the tenant stop showings? Are we able to go in and state and take pictures? To the 24-hour notice, so on and so forth. And what are the boundaries and restrictions that are hard-nosed when listing a property? Then, of course, the follow-ups, right? Like if somebody is actually wanting a vacant possession versus somebody who is if they are renting out, right, they can have vacant possessions only with certain amounts, with certain things that can go on, which is moving themselves, moving somebody that's dependent on them, or doing major renovations, right? What happens if none of that's happening and an investor is purchasing the property, which happens a lot of times, especially in condominiums. So all of these big good questions for us. I would like you to at least broadly touch on the fact that client approaches me property is rented, what are the first things that I should take care of? Should I be sending a form for trying to get a mutual release from the tenancy? Is that the best way to go around it? What would be your best advice and best practice?
So usually, when I get approached by realtors or by landlords, generally when they have a property that's tenanted, the question I get is, can we ask, the tenancy was there for, a 1-year term. The term is over, and now we want the tenants to leave because we've decided to sell the property. That's usually somewhere where the conversation would start from. And, in putting it into context, generally speaking, just because one, the tenancies come to an end, as in the agreement has, it doesn't mean that the tenancy is over. In Ontario, the tenants have the right to tenancy even once the agreement expires. It automatically becomes a month-to-month tenancy. There is no law that states that just because the agreement has come to an end, as in the term of the tenancy has come to an end, that the tenant has to move out, or that if you're not going to propose or proffer a lease agreement renewal, that the tenancy must end and the tenants must leave. So that is not the case. And also, just because you desire to sell is not a lawful reason to evict a tenant or kick out a tenant. So a lot of landlords think that, hey, we want to sell the property, therefore you must leave. That is not a fact. There's only a handful of reasons you can get rid of a tenant or evict a tenant. Unfortunately, that is not one of them. So usually what happens is when you get a tenant or when you get a property that's tenanted and you wish to sell it, that is your right. As a landlord, you are permitted to sell the property. But the reality is, and I think all realtors would agree with me, that it's easier to sell a property when it's vacant. Right, that gives the landlord the opportunity to essentially stage it, renovate it, and try to get top dollar for the property when it's vacant. So, in my opinion, the best course of action would be to maybe have just a discussion with the tenant to see where they stand. Would they be willing to vacate? And if they are willing to vacate, then sign an agreement to terminate the tenancy. That is perhaps the best way to go to try to get the tenant out, is to come to some sort of consent mutually to terminate the tenancy. But just because you desire to sell it does not mean that the tenant has to vacate or that the tenancy is at an end. In terms of, when you're dealing with a property that is tenanted, it is challenging, especially in today's market. I understand a lot of tenants are paying below, the market rent. Interest rates for landlords are going up, so now they're having to pay more out of their pocket. And you're going to have quite a bit of pushback, from many tenants that say that, what, we don't want to vacate, we don't want to move out. Sure, sell the property. And that is about as far as your rights go. You are allowed to list it for sale, you are allowed to sell it, but the reality is with a tenanted property, the number of buyers that you have that are willing to assume the tenant are really low. It still is possible. If you find another investor who's willing to buy the property and assume the tenant, that is perhaps your only way out. And that is how it would have to go.
Hmm. So, Faraz had put down a bunch of questions when we started, and you've touched on a few, but I was thinking we should maybe go with the sequence because it'll elaborate more on the topics. You
Sure.
brought up a really good point where it is that, you can find an investor who might want to assume the tenant. The problem always remains is that the rental would not be of market rent, and the big problem that is faced is as the property prices are growing, the mortgage payments on people and now the interest rate, the expense of actually carrying or the carrying cost of a property is much higher than what the rents were previously, right? So that is always a disarray, and especially because you have to assume the tenancy as is, you have to grandfather the previous tenancy. That always becomes a huge issue when selling an investment property. So, just a quick thing, rights of a tenant when a property is sold, because I know that there was a lot of new regulations that were put in, with the liberal government 2 years ago. It was just pre-COVID, So what are the rights of a tenant if the property is sold?
Well, if the property is sold to an investor, then the investor is essentially assuming the tenant, and as you said, with the same terms and conditions that applied with the initial lease agreement. They basically step into the shoes of the previous landlord. They become the new owners, the new landlords, and that therefore they are stuck with whatever rent has been decided. Now, I will say this, that landlords are permitted to increase their rent every year, once every 12 months. But you fall into two different categories. One is if the property was built before November 15th, 2018, then there's rent control that applies, meaning you can only increase the rent every single year based on the rent guidelines that have been set by the government. This year, it's 2.5%. So if it's an older property built before 2018, November 15th, rent control applies. If it's a newer property, some of the newer developments, condos, houses, you name it, that were built after that date, then there is no rent control, meaning as long as you give the appropriate notice, 90 days notice on the board approved form, you can increase the rent to whatever you wish to increase it to. There's no cap on it. So I do know that some of the newer properties would be easier to sell to investors because all the landlord has to do is give the proper notice and increase the rent. Okay.
So on the flip side, sorry for cutting in, but on the flip side of the tenant, so you give the 90-day notice. Now the tenant thinks that the rent is exorbitant and cannot afford it. They can give a 60-day notice and get out of the tenancy as well.
They can. They can even give a shorter notice if they wish to get out of the unit. And essentially, yes, they can give their proper notice and vacate accordingly. And many landlords, I'm sure, would be okay with that as well. If they're not getting what they think that they should get, then that should be okay. But in terms of the rights of the tenant, just again, so if you sold it to an investor, they're sort of, the tenants get to stay, the investor takes over. Now, if you've sold the house or the property to somebody who requires it for their personal use, this is when things can get very dicey. And I say this, and I can probably elaborate on this based on a story, just to sort of highlight some of the issues. But if you were to sell a property and you didn't know that you still have to give proper notice to the tenant to vacate, there are a few requirements for personal use. So if you're selling a property that is tenanted and the new buyer requires it for their personal use for a minimum 1 year in good faith, you have to give the appropriate notice. It's called the N12. You must give 60 days notice. You must pay the tenant 1 month worth of rent. You must compensate them for that out of your pocket. And once you do that, the tenant, according to the N12, if they believe that they wish to dispute it or they don't believe that it's in good faith, they don't have to vacate. So even though you followed the protocol, you said, listen, I've sold the property, the new buyer requires it for their personal use, we're giving you 60 days notice, and we're giving you 1 month rent out of our pocket, the tenants nowadays are still not moving out. And that leaves the landlord with only one option, which is to file the application with the landlord and tenant board and wait for the board to set the matter down for a hearing and issue an eviction order.
So for us, this is even after the first year has lapsed, the tenant is still living. The owner themselves, even whether it's new or the previous owner, they want to move into the property themselves. They send out an N12 first to begin with and an offering of the 1 month rent, even after the first year is over, right?
Even after it applies, and no matter
Okay,
what.
and if so will does the tenant has to respond on the N12 with a saying, yes, we are accepting to move out, or it's just,
No,
it's something that they have to, no.
no. The landlord, once they've issued the N12, they pay the compensation. I'm just going to say this as a disclaimer. Obviously, we're talking very broad terms, so don't take
Yes,
this
of
as
course.
legal advice. For each matter in each case, everything has to be assessed. The lease agreement, the terms and conditions. So right now we're speaking very broad terms. So please, this does not, just as a disclaimer, this is not legal advice until I've had an opportunity to obviously assess your case very specific to the lease agreement that you have in place. So yes, the tenants, even after you've done everything right, you may still have to wait for the board to schedule a hearing and do an eviction. But speaking of the current status of the landlord and tenant board, it's taking 8 months on average to get a hearing date. So this is where the problem lies, is the delays with the landlord and tenant board. In the pandemic, we had a client who had sold a property, not knowing that, just because they give 60 days notice, and they pay the 1 month compensation, the tenant doesn't have to move out. Tenants nowadays are choosing not to move out and challenging the N12 and waiting until the board issues an order for eviction. And they know that the systemic delay in the system means that they can probably get 8 months to a year or more living there, even though the N12 may be valid. So I'm just going to highlight right now that so in the pandemic, when I had a client, I'm going to finish the story. When the client had sold the property, given the 60 days, paid the compensation, the tenant decided not to move out. And my client was freaking out because they had a closing coming up in 90 days. They needed the vacant possession because the new buyer had already sold their house. They were already ready to pack up, move into their new house that they've purchased. Well, the mistake made by the seller, the vendor, was that they did not build a provision in their APS, their agreement of purchase and sale, to safeguard themselves because it's a tenanted property. And what I mean by that is, in most agreement of purchase and sales, you guys will always have a closing date that's been fixed. So it usually, in your agreement of purchase and sale, the terms and conditions usually do say that the date of the closing is a must. It must close on that date. That time is of the essence. That's also a term that's used in your APS. So when you have already set the date for closing, and you as the seller cannot provide vacant possession to the new buyer, the situation and the risk that you run is that if you don't close on that date and that new buyer can't move in and you can't provide vacant possession, you run the risk of them suing you for their damages. So in the pandemic, when this happened with my client, he was between a rock and a hard place. He said, he told the buyer that, listen, I may need an extension. I'm going to have to file this with the landlord and tenant board. And the buyer said, sorry, that's not going to work for me. I've already sold my property. I've already put my stuff in storage. I have to move my family in on the day of the closing period. But if you don't close on that day, I'm going to have no choice but to buy the house that is down the street from you for $250,000 more. I'm going to have to close on that property and then sue you for my damages and the difference. So now my client was looking at the prospect of being sued for $250,000 plus potential Airbnbs, storage costs, moving expenses, or finding a way to get this tenant out. Again, the only mistake that this seller made was they didn't put in provisions to safeguard themselves with a tenanted property. And being between a rock and a hard place, looking at the situation, he had no choice but to offer cash for keys to the tenant. He paid a good lump sum of $25,000 to the tenant to have them move out before the closing date, which thankfully worked out. But my client was left between two different options: either get potentially sued for $250,000, or let's get the tenant out with cash for keys. So just out of this story, what I'm going to say is that where you have a tenanted property, you've already sold it, meaning you've entered into a purchase and sale agreement. Please note the tenant does not have to move out just because you gave a valid notice. Build in provisions to safeguard yourself in the event the tenant does not leave, meaning build in a provision that says that the buyer acknowledges that's a tenanted property, and they will be flexible with the closing date in the event that you have to apply to the landlord and tenant board to get an eviction order. So those are just some of the tips I'm going to give when you're dealing with a property that you've sold and it's
That's really, really good advice for us, because that can happen anytime, right? And then it becomes the liability of the seller.
absolutely.
Um, what is the best course of action? You have a client that has a tenanted property. They want you to go ahead and sell it. How do we prepare the tenant, and how do we make sure that moving forward through the process of actually selling the property, what are the rights of the landlord that are wanting to sell the property?
So firstly, I think is always, and I think most realtors know this, it's best to try to come to an agreement with the tenant to terminate the tenancy. There is a termination or agreement to terminate the tenancy agreement. It's called an N11. It's a board-approved form. If all
The mutual one,
landlords,
right?
the
It's
mutual
the
one,
mutual, yeah.
yeah. So an N11 is a mutual agreement to terminate the tenancy. If all landlords and all tenants can sign that agreement to terminate the tenancy, that would be ideal. Again, The N11 can be challenged without getting into too many details or too many what-if scenarios. But ideally, you want to get into an agreement to terminate the tenancy on mutual terms. If you are able to do that, well and good. If you're not, sometimes it's just the cards that you've been dealt, and now you have to sell the property with the tenant in there. So the landlord is allowed to sell the property. There's nothing preventing a landlord from selling the property, but you're obviously going to have a very limited market that's going to be willing to take on this tenant, or a very limited number of buyers who are going to be willing to put in an offer with a tenant in there. So as a landlord, you are allowed to sell. There's nothing preventing you from listing the property for sale. You have the right to do that. The only thing is, when you have a tenanted property, you're going to have to cooperate with the tenant as best as possible for your showings. Legally, you are supposed to give at least 24 hours written notice to the tenant when you're looking to sell a property. So give them 24 hours notice minimum. Your hours of entry can only be from 8 a.m. to 8 p.m. And that is your right. I will say this, sometimes it's better to cooperate with the tenants and figure out certain days that you're going to be showing the property. I know that, sometimes you want to show the property as soon as you get an inquiry at your brokerage, that this is when we want to show it. Make it a part of your listing that your showings are only going to be in agreement with the tenant on, for example, Mondays, Wednesdays, Fridays, and Saturdays between a certain time. That way you have an agreement with the tenant, you have them sign something, you've given them pretty much notice for the next 30, 60 days that you're going to be having these showings. I would say try to work with the tenant on working out a schedule for these showings, and that's how you should do it.
Right. Yeah. I had a scenario come to me today, which is sort of interesting because it's very different from what we are discussing. A property was tenanted to a tenant. It's a multiplex, and there is problem on the tenant side. They don't like the parking spot. They don't like many things in it. Tenancy started just 1st of March. First and last month's rent was taken as deposit. I'm sorry, Vivian, I'm gonna mute you. So it was first and last month's deposit was taken, and at the end of the day, the tenant wants out of the lease. What rights do they have? Does the landlord keeps the first and last month's rent? Like how do you go around it? The lease has just started on the 1st of March.
You're going to have to make a decision on that. When it comes to when a tenant wants to terminate the tenancy before the term is over, in most cases, I'm going to advise the landlords to cooperate with the tenant on that. If you're seeing that they're not happy, they're going to give you a rough time. I do understand it's tedious and cumbersome, because you have to relist the property and re-rent it again. And so obviously the landlord's having to incur an additional cost for that. But holding a tenant specifically to the tenancy can have its own challenges. If the landlord wants to, I guess they could say, yes, you're in this term, please, move forward. Like you're going to have to, fulfill your term. Or in the alternative is to find a way to get a new tenant in. Maybe not be immediately, but maybe 3 months from now, you start showing the property and you get another tenant in. A landlord is supposed to mitigate their damages. So even if this tenant hypothetically were to get up and leave, just on a hypothetical, and they say, well, we're gone, here are the keys. It doesn't mean that the landlord now sit back for the next 11 months and do nothing, right? They still have to mitigate their damages, and they need to put in, the proper efforts to list it on MLS. You may use Kijiji or whatever, to try to find another tenant as soon as possible to mitigate your damages. And in most cases, you will be able to mitigate your damages because the rental market is pretty hot. We know the vacancy rates are low. You're able to get another tenant in right away. No harm, no foul, and really no damages in that type of context. So I would say work with the tenant. It's not worth it, in my opinion, to try to push it and get them to stay for the full term.
Sure. But they have lost, the landlord would lose the 1 month rent, right? Because it would be the real estate fees have already been paid at that point. So do we get to keep the deposit as a landlord or not?
So your deposit under the Residential Tenancies Act is only to be used for the last month, period. It can't be used for any other damages whatsoever. whether it
Oh,
be
I
real
see.
estate fees, whether it be for damage to the property itself. It's strictly used as a last month rent deposit, whenever that may be. And
Mm-hmm.
that's the thing. So this is a very unique situation, and depending on how you want to proceed with it, you do have rights, but at the same time, the question is it worth it? Um, you know, if you come to me with 1 month of rent to say, listen, do I need to pursue this to the end of the earth to try to enforce my rights? It may not be worth it. It may be cost prohibitive, right? So I would say
Right.
probably try to come to some sort of mutual agreement with the tenant.
Okay. I have another question. You may or may not have the answer for it, but in our brokerage, one of our realtors was representing a tenant. Um, Really interesting scenario. The other the the landlord's brokerage representing brokerage decided that somehow the paperwork was not legit. On the basis of that, they kept the deposit, which is the first and the last month's rent, and refused to give um, occupancy to the tenant. And now our realtor is faced with all kinds of issues, including the tenant being extremely upset with them, threatening them, um, and the deposit's not held by our brokerage because we were on the cooperating end. We were actually, and many emails have gone out from myself as the broker of record to the other broker of record, and they're just holding this very fast that they've signed a mutual release, but they're not releasing the funds, which are substantial, but by no means are they the pennies, and they're not releasing those funds, saying that no, the documents were fraudulent in their view, and they're not releasing it. What rights does that the tenant have at this point? And she's out of place because the deposit was hefty, is paid out of pocket, and she needed to move out of the other property which is sold.
So I do know, again, I don't file too many tenant applications. I usually do it more for the landlords than do tenants. I do know that if deposits have been paid, occupancy not given, I believe tenants can file an application to get the return of those deposits back. But I also understand that there's a brokerage involved, that the brokerage is holding the funds in trust. There may be an overlapping of the small claims court. I don't have the answer for you. There may be, but I know tenants can apply to the landlord and tenant board to get the deposit money back if they weren't given occupancy. I don't see how this broker is going to hold those funds indefinitely in trust, or pay them out of trust. I think they may be liable if they do. So that's where I think there may be some jurisdiction of the small claims court if your client is going to go after the brokerage as well.
Maybe I should give them your number because Rico said we're not getting involved in this. I keep sending them emails, they're not responsive. And they put this little line in their Schedule B. Guys, you must be very, very careful when you have your client sign the Schedule B, which said that if there's any fraudulent activity in the profile that may be thought, then the brokerage keeps the funds, which is ridiculous because they have no right to do that, right?
Yeah, I don't see how they're going to exercise that. That seems to be a penalty that I don't know the enforcement aspect of it, or the how they're going to be able to pursue that if it goes to court, or how they're going to be able to prove that there was fraudulent activity. They accepted
Mm,
the tenant based on the application, and they would have accepted and done their due diligence before they signed the lease. So
mm.
then to deny them occupancy and keep the funds, it doesn't make sense.
Right. One of
And
our realtor has
you
this,
can always have, I'm sure, like law is, you always have both sides of an argument.
yeah.
So I guess it'd have to play out in court or at the tribunal, depending on how it's to be pursued.
Mm. One of our realtors has this question. I have a follow-up question here. Say I'm able to get an N11 signed by the tenants of my seller clients, and based on that, I ended up selling the property of my clients in the middle of the firm accepted offer. Um, and the closing, suddenly the tenant refuses to vacate, and the buyer needs to move in at closing. Can the tenant behave like this? Yeah. If yes, that would be my way to move forward and save the best interest of my seller clients. also based on what I would have advised my seller client situation and N11, is it a conditionally accepted offer, or my seller client can issue an N11 without conditionally accepting an offer? N11 can be done at any time because it's a mutually accepting, tenant is saying I'm leaving the property, and it has nothing to do with an accepted offer, Abu.
So an N11, like I said, although um, tenants can challenge an N11. So for example, I know some N11s have been set aside because the landlord misrepresented as the circumstances why they were signing the N11. Another thing is you can always ask a tenant for an N9. So sign an N11, but have a tenant give an N9, which is a notice to terminate the tenancy as well. That is another way to do it because it's coming only from the tenant. But there are some provisions for the N9, such as the tenant still has to give proper 60 days notice minimum and what have you. But even at any time it is a tenanted property, whether you sign an N11 or not, you still want to build in provisions to safeguard yourself, just like the scenario that's playing out right now, where even after the N11 is signed, the tenant has decided not to move out, right? So you still want to make sure your APS has terms and conditions in there to safeguard yourself in the event of, right? So even though the tenants have signed off on the N11, again, all tenants, and when I say this, I mean this because a lot of the times there's multiple tenants. Unfortunately, on the N11 form, there's only one area for a single tenant to sign. I recommend you use the blank space at the bottom to get the other tenants to sign and date it and print their name. But in any event, an N11, just because it's signed, a tenant decides not to move, the only option you're left with is to file the L3 application with the landlord and tenant board to seek an order for eviction. So to put this into context, as soon as a tenant signs an N11, I tell my clients not to wait. Even though that N11 may be for 90 days down the line, don't wait until that day comes and you realize the tenant's not leaving. Spend that little bit of time, money, and effort to file the application with the board, just seeking an order for termination of tenancy and eviction based on the N11. And the sooner you do that, the sooner you get an order, and hopefully the sooner you can enforce it. So in this case, if I were the realtor, I would definitely say, build in provisions to safeguard yourself for this exact same scenario.
And Furaz, I have a follow-up question. Like you mentioned that we could ask the tenant to issue an N9. Now, that has to come voluntarily from the tenant, right? And how do I put it across so that it comes from them? And even in that case also, like in the middle, again, they back off. They say, no, I have signed an N11, like N9.
An idea.
So hard. I couldn't find a place. I'm not going.
Hardworking people, they're honest, proud people.
I'm so sorry, I'm getting a little bit of interruption in the
Yeah,
background.
I just muted person that was talking. Sorry, go ahead.
Sorry, so with the N9, again, it's just a discussion with the tenant. You just want to have that discussion saying, listen, this is circumstances. This is what we're looking for. Are you okay to terminate the tenancy by a certain date? And if so, are you okay with signing this N9, right, where you're giving me this notice? Now, I think that might make them a little bit reluctant, and rightfully so. I think the N11 is the most appropriate, where it's a mutual agreement based on certain circumstances. But if you do have that, it's usually a discussion saying, listen, here's an N9. Can you, issue this or sign this and give it back to me? I would use that more as a secondary than I would as a primary. Primary is still the N11, which is an agreement to terminate the tenancy between the parties.
Mm-hmm. And then even if I end up getting an N9 from them, that they understood my concern, they voluntarily signed an N9 and gave it to me. And then in the middle of the process, they ended up saying that, okay, we couldn't find another place and we don't want to get it.
Yeah, and that is the unfortunate part. It happens all the time. And this is, again, as soon as you get an N9 or an N11, you want to make sure you file that application, the L3 application, with the landlord and tenant board right away. And trying to get an order to terminate the tenancy and evict them if they're not out by that date. So the sooner you file it, because there still are delays at the landlord and tenant board. Prior to the landlord and tenant board recently changing their online tribunal portal system, they used to have a different way of doing it. They've introduced a new technology. There's a learning curve with that at the board itself. So there's still some systemic delays from that new technology being rolled out. So I'd say the sooner you file the application, the better it is for you so that you can get an order. Now, that's not to say that a tenant can't bring a motion to set it aside. Again, it happens all the time, right? Where you've done everything right. You got the N11 signed, you filed the application, you got an order in the mail saying that tenancy is terminated. At the end of the order, it is written that if the tenant wishes to file a motion to set aside this N11, they may do so within a certain amount of time. And the tenants, they may file that motion to get a stay of the eviction. And then you are stuck having to wait for the board to file or to set the matter down for a hearing. And then both parties go there to present their cases as to why the N11 is or is not enforceable.
And what's the
There's
time?
just open forum to other questions. Abu, take his number, call him up. Just so that everybody gets a quick question in there, that would be lovely. So anybody who has any other questions, because we are coming at the end of the hour.
And just before I do cap this off as well, I do want to say this, that many times when someone asks me, can a tenant do this or can this happen? Almost 99.9% of the time, the answer is almost yes. Anything is possible. And so, you know, you could do everything right and tenants bring motions to stay or stop the order for enforcement. It's the way the system, the law is. And I would have to say that many things, unfortunately, aren't so fair under the Residential Tenancies Act for landlords. But we're part of the system. I think the best thing you could do is find out ways to mitigate any damages that your clients may have to suffer when the property that you're selling or buying is tenanted.
Hi.
I don't know who's up next. Furaz. It's Karen speaking. I normally have questions on the landlord side. This particular time, I have it on the tenant side. I don't know, and this is personal, is the tenant was under duress to sign a new lease. She was first given the N11 to move out, said that they needed it for the son. And anyways, then the landlord ended up coming back to her and says, I'll give you another year's lease at a $750 increase, which was huge. I mean, it was 74% increase in the rent. This has happened 3 months ago. It's illegal. What is her best, at this point, she is going to move out, but she would like to go after the landlord. I think she should, for this illegal
Rent increase.
Rent increase, yeah. Should she go to, like, go to the landlord and tenant board, or should go to small claims court, or hire someone? I mean, it's.
I understand the question. So generally speaking, obviously what the landlord is doing is illegal. In fact, right now, many landlords are doing this. I know too many that are doing this at the moment, where they'll say, hey, you know what? We haven't increased your rent for the past 5 years. We're such great landlords. And now, you're paying $2,000 for a condo, a 2-bedroom, 2-bathroom at Square One, which the average rate right now is between $2,900 to $3,000. And you know what? The interest rates are going up. The market rate is so high. We want you to pay market rent. And so that's basically what's happening. And if you don't pay market rent, we're going to have no choice but to then maybe have one of our children move in because it's cost prohibitive for us to keep it. So it's sort of putting the tenant between a rock and a hard place, saying, listen, either agree to this or we're going to do an eviction for personal use. And many are doing that. So as a tenant, and I'm going to play devil's advocate over here, although majority of my clients are landlords. A tenant, if you are smart and you do a little bit of research on the law, you're going to realize that that rent increase is illegal. But if you want to secure yourself in another year lease so that they don't, try to start the process off for an N12 personal use, you should just agree to it. Agree to signing the lease, and I'm again only playing devil's advocate here. Sign the lease, but request for not one. Ask for a 2-year lease. Say, fine, I'll pay you the $750. Hell, I'll pay you $1,000 more a month. You can sign the lease because it's under duress. and you feel that, and it's an illegal rent increase. But once you sign it, by law, there's nothing that requires you to pay that illegal rent increase. And so I've known tenants that have done this to the landlords as well, because they outsmarted the landlord and said, listen, yeah, okay, fine, we'll pay it. As soon as they sign the lease, they say, you know what, we did our research and we've consulted somebody and we find out that it's illegal. We're going to revert back to the original lease amount, which is X amount of dollars, $750 less or whatever it might be. And guess what? The landlord can't do anything about it. Not just that, the landlord is now stuck in a 1-year lease or a 2-year lease, and they have to wait until that lease is at an end before they can ever get an eviction for personal use. So your client technically did not have to move out, but if that is the choice that she's made, she may have an application for harassment against the client, against the landlord, and that the landlord interfered with a reasonable enjoyment of the property. Again, whether she wishes to do that, and what the outcome is going to be determined by the board based on the evidence.
So based on that, are you saying would she go to the landlord and tenant board for the harassment, or small claims court for the harassment, or at this point, knowing that she is going to be out within 10 weeks, should she then deduct the increase of rent to the current rent payment?
So the small claims court has no jurisdiction. So I'll just talk about jurisdiction. Recently, there were certain bills that were passed, including Bill 184, which clarified a lot of the roles of the courts versus the tribunal. Most of everything that transpires between the landlord and tenant in a residential matter is governed at the landlord and tenant board. Exclusive jurisdiction has now been given to the LTB. So that is the first point I'm going to make. Second is, if she's decided to vacate, are you saying she's been paying an illegal rent increase of $750?
Correct.
Well, then she can have that deducted and she can make her point clear that she's deducting that because that was an illegal rent increase.
Okay.
And she can file an application with the board also to make that determination as to whether or not it was an illegal rent increase, and if she feels that this is harassment or an interference with her reasonable enjoyment of the property.
What particular form should she use to file the application for this?
There's different T applications. I know there's a T2, T5, T6. She may have to use a combination of them. So she should look at those notices or those applications and then make a determination as to how she wants to go ahead with it.
And you can also share Furaz's information with her if she wants to use his services. Because I think, Furaz, I'm going to give you a call right after this because I have an issue at hand with my mother. And I'll tell you all about it. So my mom's in Emerge, cannot. So I had a basement apartment made for her with an elevator in it. She's come to that place where she had to be taken up the stairs by firemen, like 8 paramedics carried her up. So she cannot go back into the basement. So she has an apartment at Square One, which was rented. Last year, I tried to ask the tenant because similar situation had happened. And this year, it's so bad that she cannot, no way can she move in there. And the tenant keeps saying that, how is she going to find another place with such a low rent? So I do need to get in touch with you because this has really come to that urgency where mom really needs her apartment and this tenant is not willing to move. And I don't want to take care of this. I would rather that, it be taken care of by someone who's.
You know what? And absolutely, I'll help you out. And whether it be an N12 for personal use, even if it's an N4 for non-payment of rent, many landlords believe it's simple as filling out a form. And although I wish it was that simple, there are so many pitfalls where, I've represented tenants, and I could share those orders with you as well, where I knew that the landlord had made one technical mistake on the notice, on the N12 or whatever it would have been. And as soon as I discovered it and I was representing the tenant, what I did was very simple. I stayed quiet. I, in fact, didn't even let the landlord know that I've been retained by the tenant. Why? The technical mistake was what we call a fatal error. And we waited 8 months for it to go to the landlord and tenant board. We went to the landlord and tenant board, I represented the tenant, and within 5 minutes, I had the applications dismissed. Why? A simple technical error or a fatal error can have your application dismissed, and then you have to start the whole process all over again. And that is why, in my opinion, you're hiring a licensed paralegal or a licensed lawyer who's familiar with the Residential Tenancies Act, the forms, and more importantly, the board's rules around how to serve documents, how things have to be done properly, is so that you don't make those mistakes in the beginning that will cost you more time and money down the line. I'll give you a simple example. If you're renting a house that's got a basement unit and let's say an upper floor, and you don't mention, for example, you're trying to evict the tenant in the basement and you don't mention basement unit, or let's say the upper unit, that small mistake on the notice is a fatal error. And you can wait 8 months to get to a hearing only to have a sophisticated representative or tenant on the other side who makes a very simple argument and says, sorry, the address is incorrect. It doesn't mention the unit number. It doesn't comply with the Residential Tenancies Act, and it'll get dismissed on a technicality. Right? So there's all these pitfalls that you have to be aware of. And obviously it takes, I can't give years of knowledge in a 1 hour call, but it's impossible. But at the end of the day, as landlords, you do need to become a little bit more familiar with the Residential Tenancies Act, the process of the Landlord and Tenant Board, and just sort of familiarize yourself that there's also a lot of obligations on you, whether it be for maintenance, whether it be for anything else. You need to get a little bit familiar with it and sort of educate yourself on it, just so you have the basics down. And for anything else, reach out to a professional. There's a lot of licensed paralegals in my field that are highly qualified. And I would say always reach out to a professional if you want to have things done right.
I have one question, Furaz. It's very educational, your whole topic. I'm a landlord myself. Only thing I heard a few times from you today, safeguard on APS. So what kind of condition we can put there in case we have to sell the property and let's say the tenant doesn't want to move, how we can protect ourselves not to get sued by the next buyer?
So this is where finding the right buyer is also just challenging, because in the APS, and again, I worked on this with another lawyer colleague of mine. So don't take this again, just a disclaimer. Don't consider this as legal advice, but I'll give you some of the pointers that we had put in for one of his clients. For one of my colleagues who's a lawyer who reached out to me, and then we had worked on this together. One of the examples I'll give you is, if you are the seller, then definitely you want to include a term where, for example, if the buyer requires it for their personal use, and they've intimated that they're going to move in and they're required in good faith for a minimum 1 year, you have to let the buyer know that the closing date, they will be extending the closing date as reasonably as possible over the next 1 year, if required, in order to evict the tenant. The buyer is aware that it's a tenanted property and that you may have to go to the Landlord and Tenant Board in order to evict the tenant, and it may take a significant amount of time. So they will be flexible with the closing date. So basically what I'm saying is time is of the essence, and that agreement needs to be canceled out. And the closing date, there needs to be a provision to build that in. You also need to tell the buyer, and in this APS, you need to include a clause that the buyer will cooperate with the vendor's paralegal or lawyer in the process of the eviction by providing an affidavit that they require the unit in good faith for a minimum 1 year, by potentially having to attend and testify at the Landlord and Tenant Board hearing as well. So these are just some of the provisions that you would want to include. And then obviously buyers are going to include a clause that states something like we did in this example where I was assisting the lawyer, that in the event that the board is unable to schedule or order an eviction by a certain date, let's just say 8 months, 9 months, 10 months down the line, then the agreement will come to an end, will be null and void, and that the deposits are to be returned back to the buyers. They had some sort of provision built in that to protect themselves. Obviously, if it's not going to happen and they're not going to get vacant possession by a certain deadline, most buyers are not willing to keep an indefinite, timeline to have the closing. So you need to build in provisions like that, because when we get to the Landlord and Tenant Board, we need the buyer to testify. So just keep that in mind.
Basically, it's a one-sided contract is a favor of vendor, right? Not the buyer. Buyer cannot ask for
it's in favor. Exactly, and that's what we're putting in the agreement. After a certain date, the agreement will be canceled, will be null and void, and that there's no damages. The buyer will get their deposit money back, whatever it might be. Obviously, that again, everything is in the board's hand. You can't unfortunately do a whole lot. You're sort of at the mercy of the board scheduling the matter for a hearing.
Thank you very much. It's very, I can use your service in future for sure. So we'll get
No
your
problem.
information from Ms. Sabiha. It's great information. Thank you.
Thank you so much for us for this hour. It was extremely knowledgeable, and I'm very excited to make this connection with you. And I'm hoping that the brokerage is going to, really benefit from this partnership moving forward.
No,
Thank you,
definitely.
everybody,
Thank
for
you for having
joining.
me speak.
I have put in Furaz's information here. I will be sending the recorded session with his information yet again, so please save that in your telephones.
Everyone, thank you so much. And if you do happen to call, and if I don't answer, it's a possibility that I'm already at the landlord tenant board or in court for a hearing. Please always leave me a voicemail or shoot me an email. And I do return phone calls when I can, usually within 2 business days. If it's urgent, email is the best way to communicate with me.
Yeah, email's almost always best guess. So thank you so much for joining, and thank you for us. Have
You're
a good
very
day.
welcome. Have a good one. Bye.